So let's start the webinar, guys. So, hi Karan.
Hello. Hi, Nitya.
Hi Pratap. I think Pratap is
Hello,
joining.
hello, hello. Hi.
Hi
Hello.
Pratap. So today's webinar is all about how patent and intellectual property, like in IP, how a patent plays a crucial role in protecting the, protecting and promoting the innovation. So throughout this webinar, we will look on the faces of the patent, the aspects, and here bit around we would explore the other IP sectors also because it is interrelated, right? So it is completely driven on patent in technology, right? Where our friend Pratap is an enthusiast. So before that, Pratap, I would start with an opening question. Like, what do you think about the recent developments, right, in patent field? Right, there are a lot of applications are, you are now overwhelmed as an expert seeing such applications. What do you see as an growth and comparatively before and after, if you see, a statistics or data, how do you see the patent in technological sector and IP in technology? How do you want to address?
Uh, right, ma'am. Right. Okay, so I would like to start with the example of one case that happened in later 20s. That was there was a company of named as Riva Technology of Bangalore, which has first implicated regenerative technology in electronic vehicles. So what was that key? They were actually charging the batteries of the vehicles while applying the brakes. And later on, there comes Tata Motors that also did the same thing. And so later, they both Reva Technologies and Tata Motors get into patent dispute.
Mhm.
So we can see that over a period of time, such inventions are originating from India or our country. So it is basically nowadays we can see the people of all around the world are actually witnessing significant interest in whether it's automotive industries, artificial intelligence, or all the technologies all around the world. So, also, I would like to put more emphasis on the importance of patent. Like, I would like to cite an interesting example or the interesting controversy that happened in later 1870s. There was two inventors actually, Elisha Gray and Alexander Graham Bell.
Hmm.
So, as we know that the inventor of telephone is Graham Bell, but there was another person named Elisha Gray. So they both have this idea, but yes, Graham Bell reached 30 minutes before Gray in the patent office to file this idea of basically transmitting speech electrically. So that was the whole novel concept of telephone, what we use in telephone. So just because of this, just because Graham Bell reached 30 minutes prior to his counterpart Elisha Gray, so he got the patent, and he's now known as the inventor of telephone. So, like with this example, we can know that what is the importance of patent. It's basically a legal right which actually give uh, the liberty to inventor to actually prohibit anyone else to make use or sell their inventions without giving them exclusive rights. Yes.
Okay. Karan, and you should say, like, how do you think it's going to be in the pioneer of IP? Like, India has been a lot of university students, individuals have been, out
Hmm.
upright getting applications for patent, and we have been, progressively stepping ahead. Our games are leveling up. So what do you think in the field of IP? Would patent be the future, or what is it that you in terms of how is it interrelated to trademark design, or do you think it is just a separate sector, or you think it's interrelated to each other?
Sure,
Uh,
Nitya. See, again, with respect to the patent sector, it is scaling up at a very fast pace in India. And not actually only in India, internationally also, people are understanding the value of idea. So whenever anybody is coming up with these days, every business, you see any business in the nook and corner that is being set up or started by any small person, it all revolves around an idea. And every idea, we need to understand there is some or the other kind of an IP that needs to be protected and that can be protected. And that IP can be in the form of trademark, copyright, patent, design, GI. It can be any of these formulations. Out of that patent, in the recent times, we are in the technology driven time that we are in the current decade where AI is being involved in every second thing. There is metaverse coming around. There are every 5 years there is a new technology that is coming around. So to counter it and to keep on adapting to it, protecting that IP is becoming very essential. And the best way to protect such kind of technological advancements is through patent. So yes, considering in India, I would say last year 2024, I think there was a report that was released by the patent office wherein they have confirmed roughly around 1 lakh patents have been filed. And you'll be surprised to know that roughly around 50%, 50 to 60% of the patents have been filed by colleges, college students, professors, deans. So it's actually a very good, and on a positive note, this is an increment that we are seeing that everyone in the industry, specifically the newer, all the students, everybody is understanding why IP is important. Colleges are promoting it, be it medical college, engineering college, professors, everybody is understanding why is it important and the need to do to protect that idea so that at one point of time it can work around as a source of revenue, as a source of idea, as a source of monetization of that idea. So there are various ways that they can use that. So that's how patent is growing. But yes, and the last point, Nitya, that you asked, the relation of patent with other aspects. There again, it's all, as I said, under IP, patent, trademark, design, copyright. These are the four major ones that comes together. And I think when you start a business, they just do not have one IP; they always have more than one. So,
Correct.
so that's where everybody has to take see that they protect all or whatever there is there in their business and apply it accordingly.
Okay. Okay. So Pratap, as the IT sector continues to, evolve, we can expect more patent fields in like AI, quantum computing, blockchain technology, cyber security. There is a rise of these technology that presents both opportunity and challenges. How patent will be applied and enforced in the global marketplace, right? So, what are the common challenges that an applicant in these fields like AI, quantum computing, blockchain, cyber security would face? Like, what would you say as your, pro tip, or these are the things that a person could face as a challenge, or it's a golden rule which you have to? What do you see in your day to day life? It would be great if you can tell the people.
Yes. First thing which I would like to specifically discuss about is that first of all, we should know what we are inventing. Does it have some industrial usage? Second thing comes whether something like this is existing in the prior art or in the public domain. So basically, these two factors are most important criteria whenever we think of getting a patent. I will give you one example. The smartphone we are using, which everyone use. I think like how many patents that this handheld fold phone might be carrying. It's around 2 lakhs patents. So a single device that we are using every day, that is having around 2 lakhs 50,000 patents. So, and I'm just talking about patents, even IP. If you see the designs of patents, design of the camera they are using, everything is covered under IP. So it's again the huge number of patents that we are carrying, and that is the significant reason why what I would like to mention ki our homegrown brands like Micromax, Spice, they actually fail to sustain market value. That's because they have cost cutting in licensing itself. So coming to the criteria of patentability, like how we should think and how we should take this, how we should take this approach forward. So in case, first thing is, like, if I am thinking of something, like when I was in college, I used to have many ideas, like there should be a car that can even be driven into waters as well. So I used to have such kind of ideas. Then I did some research as well about that, and I got to find that such cars are actually existing and the patent has been filed. So first thing we should go is that if we are thinking of filing a patent, we should know ki whether such thing is available in the public domain or not. For that, first thing is we have to conduct a patentability search. Patentability search is basically an extensive search that is conducted to actually find whether something like that which you are inventing is existing in the prior art or not. And I won't say ki it can be done by, oh, like, see, if I am not a patent professional, so I can like simply search on Google, and also it's not like that. The person who is experienced for 5 or 10 years can only do that, because as I give you the example of the car that can be driven into roads and as well as water. So you might be simply searching with the strings, the car that I can drive on land or I can drive on water. So you won't get the relevant results. You will get the relevant results, but it won't be covering the everything like what you are thinking. So there is a word called as amphibious cars. So this particular word that is given to these type of cars, which can be drive, which we can drive on roads, and that can be driven onto sea as well. So there is particular term amphibious that only the experienced person can actually search that. So first step is patentability search. You have to refine thousands of patents, because this is the technology you are working. Many are working like that. So once refined, you have to be confident enough ki, okay, my idea is unique than the one which is in the public domain. If I'm able to find that, then I should proceed with drafting. Drafting also, there are two types. One is provisional drafting and another is complete specification drafting. Provisional specification drafting is specifically to actually secure a priority date. Priority date in the sense it is the filing date. Like as in starting, I have given you the example of how two inventors, Gray and Alexander Graham Bell, just there was a difference of 30 minutes. If Gray might have reached 30 minutes before prior to Graham Bell, so today he might be the inventor of telephone. So the one who files first, the invention belongs to that person. So yes, many clients or many people I have interacted, they have this thing ki, I have worked little bit on my invention, but I need some time to actually complete my invention, or I should have some experimental results with me. So for that, I suggest you go for provisional specification drafting. So at least your overall idea will actually get a priority date. It will be filed. You will get a date. So before, after that, any person comes and he files a similar patent like you, or similar invention of you, like you he's carrying. So he won't be able to get that patent because you have filed before him. Once, now you get 12 months of time. If you have done with all your research and experimental work, you have seen the marketing trends, or if you want to add some more things into your basic idea that you have already filed in provisional specification, so you have 12 months of time. You can actually extend that specification. You can include everything in complete specification. There will be most important part that will be added into your draft, that will be claims. So claims are basically, and also in the most important from claims is also the independent claim. Independent claim is the one which will actually protect you from getting it infringed, because when anyone is using a product which have your claim covered in the independent claim itself, so you have rights. You can sue him, or you can actually send notice to that party, okay, but you are infringing my patent. So once you have done with the drafting process, then we proceed for the filing process. And filing, it actually takes around 3 to 4 years in India. Several parts of countries like Japan, Singapore, they have little bit lesser time. They take around 1 to 1.5 years to get the patent grant. But yes, there is a route known as expedite route. You can go through that if you want to publish your patent early, or if you want the grant of patent within 1 to 1.5 years, then this is the right way you can opt for, and that you have to opt after filing itself. But yes, if you want to file countries like where I can get the grant in lesser number of time, then in lesser time, so then you should opt for countries like Japan, Singapore, and Australia as well.
Understood.
So basic overview of patent process.
Yeah. Okay. So I would now open questions from the, our, our participants. So let us wait for the questions. Okay, the first question is, can edge computing solutions integrated with AI models be patented for specific industries like healthcare or logistics? Um,
uh, okay, so yes, the answer is yes. Edge computing solutions can be integrated with AI models, but yes, it should meet the patentability criteria for that. Suppose if there is an edge computing solution which actually reduces the latency and improves data privacy and processing sensitive patient data locally in healthcare device, so we can see that it is bringing something, it is actually reducing the latency, it is increasing. So in that case, we can, yes, we can get patent of such edge computing models.
okay. So there
uh,
is another question. I think it's for Karan. So how detailed should be my claims to be protected, both algorithm and its industrial application?
See, normally when you're applying for patents under patent law, you can have max to max roughly around 10 claims. You can have much more claims also. But yeah, normally I've seen people go for anywhere between 10 to 15 claims. And how elaborate? See, when you're writing about claims, it's not about being elaborate, it's about being finding the right pointers, which are the unique aspects about your entire patent, or which are the unique features that you feel are there that are in the patent. So if you have 2 or 20, the number does not matter, but you have to be talking about the exact and the most unique features that are there. And make sure they are different from any other similar claims that have been already filed or are already existing, so that there is no overlap.
Okay. So, how do I protect a hybrid hardware plus software invention combining IoT sensors and machine learning algorithms? Pratap, would you like to answer?
yes. Okay, so first I would like to start with okay, so when we talk about machine learning algorithms, so if we talk about see, I have mentioned the criteria for patentability. First one is it should be novel, it should be non-obvious, it should not be known to the person who is skilled in the art, and third one is industrial applicability. Including that, there is one more feature, there is one more important criteria for patentability, that is key: it should not lie in the sections or non-patentable subject matters. and in Patents Act it is clearly defined under Section 3. So when we talk about algorithms, Section 3K is what actually specify these key, the algorithms or machine learning algorithms or computer programs, they cannot be patented. But yes, there are certain ways we can actually get patent of that. We might have seen the example if we look into the okay, so you might be having question. Zomato and Swiggy basically both are same only. They have interfaces, different interfaces of course, but yes, functioning same ही है. Like they are functioning on the same inventiveness or novel concept एक ही है दोनों का. They are used for uh, delivering items. So in that case, if you say ki do Zomato or Swiggy have filed patent on that, the answer is no. But yes, if you see the route optimization technique, you can see when you open, you can see the live location of the delivery partner. So actually, that feature is patented.
Okay.
So yes, in my opinion, uh, hybrid hardware software inventions, IoT sensors are patentable. But yes, it should. I would specifically like to mention this: the hardware and IoT things should be enabled in that process. Not only algorithms that we can seek patent for. For that, you have copyrights. Section 2O says you can okay, you have code structure, you can get copyright on that, but not on patents. But in patents in India, you have in Indian jurisdiction, you have to apply that software application with hardware component that too have some must have some technical advancement. Like in this case, I told you we can see the route optimization technique. I can actually view the live location of delivery partner. So how my food is actually allocated to the nearest delivery partner or the delivery partner which is standing outside that restaurant. So automatically that order will be allocated to him. So that this route optimization technique combined with hardware is a whole process. So I can seek patent for that.
Understood. So the next question is, Karan, can I apply for process patent? Process is a protocol for treatment that we follow internally. This includes multiple things like nutrition, fitness, and therapy. Anyone you could answer.
Okay. Okay. So thanks, Nitya, for the question. With respect to this, if you have a unique process which is solving a problem, yes, you can apply for the patent for the same. You do not always need to have a machine or a software or technology to apply for a patent. So, like for an on a nutritional specific, so if you have, there's something called as recipe patents also. So if you have created a kind of a mixture or something which is having a different way of making altogether, which is having a unique recipe of making, that thing you can apply for it as a patent. If you have come
Like
up with
Coca
any,
Cola.
like although Coca-Cola has not done it, have not applied for a patent, but
Yes.
yes, on something around on that
Yes.
lines. So, like again, many people in the industry even apply for patents on the for alcoholic drinks that they make, or the entire recipe for making an alcoholic drink, or an entire recipe of making any kind of a unique dish that they have come up and created it. And it's not simply a mixing of 5-10 things; it's about the way of making it, so that you can protect in a nutritional way. If you're a nutritionist or something, then you can apply if you have created any kind of nutraceutical based product. If you have created a product which is having nutritional benefits, kind of a tablet or a medicine, currently in India a good chunk of patent applications that are being filed are medicinal patents that have been filed. So yes, if you have that kind of product that you are creating for your customers or for your clientele, you can apply for a patent for the same too.
Okay. Karan, one more follow-up question. What risks should I be aware of when patenting AI-based fintech solutions across multiple jurisdictions?
AI based fintech solutions. See, there are two aspects to it. Firstly, make sure it is not an open source. It's a very common mistake. What I'm seeing is people are taking up an open source coding or an open source software or a technology or a product which is already there in the market or which is made public for free, and then they're trying to apply for a patent for the same. It's like many people try to do with Chat GPT. They took that, they tried to put it in their own system, and then they're trying to apply for the patent for the entire overall system. So you cannot have a patent for something which is not even created by you. So make sure whenever you are applying not to use anything which is there in the open source already available. Second aspect is the three eligibility criteria, which I think Pratap already elaborated upon it: industrial applicability, novelty, and non obviousness. It should not be there existing in the market. It should have something unique, inventive feature added in it. And it should be industrially applicable that actually somebody actually ends up buying. If you create something which nobody buys, then that becomes an entire moot point about it. So, yeah, if it's meeting these two headings, you can apply.
Okay, Karan, there is a follow-up question for the process patent. So the participant is telling, I was trying to refer for an operational process or a protocol. For example, it's 12 therapy sessions, 4 nutrition sessions, a span of 6 months, etc.
Okay. See, if you have a therapy session with a span in a few period, we have to actually delve into that. What are the uniqueness or the what is the unique process that he or she is applying in the entire process, and what are the results that it is or the medical benefits that it is giving. So I would be wrong to comment, you can do it or you cannot do it. At the end, it depends upon how is the process and how is the process unique enough. If the process is unique and it is having genuine effects which has not been done or which has not been achieved by any other process, there are instances that such kind of patents can be applied.
Okay. Karan, again, a question for you. Should I consider a joint patent filing if my technology relies on my partner proprietary hardware?
Well, I didn't get your question, Nitya. Can you repeat again?
I read. Should I consider a joint patent filing if my technology relies on my partner's proprietary hardware?
Yes. Again, see, if you have something which your partner has created in a company, so there are many companies who are just tech or product based companies. So the entire product is the business. So the person who is CTO or the person, even the CEO or the CTO itself of a company, when they have created a unique product, that person, another person can jointly apply for a patent application. So when you are applying for a patent application, there is no limit to around how many people can be joint applicants. Two individuals can be joint applicants. Two companies can be joint applicant. One individual and one company can be joint applicant. So, and even the number can go into three, four, five number of members also who can jointly apply. Whether,
Prabha, yeah, sorry. Go ahead.
yeah, the only one last point, many people are end up asking ki whether we should do it as a joint or we should do it as a singular entity altogether. I normally say again, whichever entity is actually going to end up using that patent, it is always suggested to have that entity as one of the applicants. So keep that in mind for anyone who is doing it. So keep that in mind.
Okay. Pratap, there is a question. What are the best practices for creating a patent portfolio for multifunctional device ecosystem? IoT multifunctional device.
Okay. So again, I would like to delve into the uh, algorithmic aspect of that. If we are using IoT, if we are involving IoT and we are creating a system, taking IoT in the account, so we have to see that key the results which I am getting. Suppose if I am using a sensor to actually note my heartbeat readings, है ना? So that process ki how that sensor is actually processed, how is that sensor taking the readings, and how it is actually gets processed, and how it is actually giving the output. So I would be more interested to know the process rather than just simply using the IoT devices. So the process here, how the processing happens, taking readings from various sensors. So that is actually bit interesting for examiner as well.
Yeah. So, generally, what is the cost and the timeline for filing to getting the patent for a hardware consumer device if they are targeted to USA geography? So, the person wants to know the ballpark figure that could help him.
Okay. So basically, okay. So like the viewer wants to know about the overall costing and charges when we are filing in US
Yes.
jurisdiction. Okay. So for that also there are various means, and that actually depends on the revenue, his like whether he's individual or he's having startup, or how much turnover his company is making. So there are separate segments, and the charges are different from each for each segments. Like if we take the example of India as well, India only. So the normal applicant, the filing charges is 1600, and it is even more for if he's not startup or individual. So similarly, in the same way, it depends in the US jurisdiction as well. Also, it also depends ki by which way you are filing through there, like whether you are going through Paris Convention, whether you are going through Patent Cooperation Treaty, or whether are you applying individually. So if basically you are Indian and you are seeking filing patents abroad, so first you have to there are additional charges in India as well, because you have to carry the FFL license, that is foreign filing license. Once you get that, then it will be solely depend on the turnover or how much your company is making, whether are you individual, you are a startup, or you are MSME, or if it is a like based on turnovers, you can differentiate those segments, and it depends based on that.
Good.
For PCT, it is if you are filing in US, it is 20,000 if you are individual, and if you are going through if you are a MSME, then the charges extends to 1.5 to 2 lakhs. I'm not sure about the figures, but yes, these are the approx figures.
Okay. So there is another question. An unique feature which is developed in security camera mobile app. Most of the app functions are widely used, but only a specific feature is unique. I want to know if this can be patented. He wants to just specifically patent a feature.
Okay. See. Is, okay. So he basically wants to get patent for that authentication portion, if I'm not wrong.
Yeah, he wants to be just the feature, and the process or the method has it to be
Mhm.
fully. Is it necessary that it has to be completely patented? Yeah.
Yeah. Yes, yes. It is necessary because as you are involving with algorithms and authentication aspects, so yes, the method and the process is of prior concern.
So even if even if there is a small aspect, if the product is huge, even you have a small feature of the product, even be it that a mobile application or a or a combustion system that is there, you can apply for a small feature. Does not mean that you have to apply for the entire product as a patent. If you have one small feature of it, you can apply for that also as a patent.
Understood. Hmm. Any more questions? How do I ensure the patent covers all the variants of modular robotic system?
Okay. Can you come again, please, Nitya?
Yeah. How do I ensure my patent covers all the variants of a modular robotic system?
Okay. Okay. So you want to know ki whether your patent covers all
All
the
the variants.
variants of modular robotic system. For that,
Yes.
uh, thus the best suggested practice is to draft broader claims as possible. You won't specifically have to write key. Yes, independent claim should be specific, but yes, if you want everything that see in claim structure also there is independent claims and there are subsequent dependent claims that are dependent on that independent claim. So uh, so you want to actually draft the broader claims if you want to cover the whole core system architecture and essential modules that are involved in the robotic system. Yes.
Be assured that your description also covers all the functionality in the broader way. So that will be the best suggested practice.
Okay. Should I prioritize patent for a specific market segment like e-commerce, automation, and China?
Uh, can you come again? I didn't got it actually.
Should I prioritize patents for a
Mhm.
specific market segments like e-commerce, automation in China?
Yes, I guess. See, if your technology has significant commercial potential in a specific market like China, I would suggest you to prioritize patenting there itself. And that actually depends on the research, uh, what you have done based on jurisdiction. If you find that yeah, your market is significant, it is showing the significant commercial potential, then you should go for filing in China. Yes, and if we talk about China, it has rapidly growing e-commerce infrastructure there.
Okay.
Yes, but yes, do it as early as possible to actually stop others from infringing.
Okay. Waiting for the next question. Should I wait for the feature to be in production? That is the question, Pratap, which I'm referring to. That
Hmm.
1 second. It's typing. The one security mobile camera app which we were talking. So the same person is asking, should I wait for this another the feature to be in the production, or can I patent even before it's actually developed by the basic architecture and a prototype?
No, no, you should patent it before. See, whether you are looking for a key feature or the whole set of features, that doesn't actually matter. What matters is your independent claim. That one key feature, how it is actually helping or assisting that whole process to actually reduce the computational processing speeds or having some technical advancement. So that has to be done prior. That is the like first step. You should move to the filing. Filing a patent is the first step.
Okay. So one more question. It's for Karan. Can I patent an anti-hacking method integrated into smart contracts for cyber security application?
Why not? If again you are creating an anti-hacking software, and again if any specifically, if you talk from an international perspective, Indian laws are a bit stringent about protecting of softwares. So in again in India, it is a requirement that a software should work along with an hardware for it to get a patent around on it. So that's where you have to showcase okay, how your anti-hacking software is working along with your system and devices around on it. You can do, but yes, it's a very common phenomenon wherein such anti-hacking softwares are being applied and protected and patented very easily across the world, be it in US, UK, EU, specifically in China, Japan. So there are many countries, and in a simple way, yes, it should be protected. It can be protected. And to add it on to what you were asking earlier, also, whenever anybody is going on a software or an AI based system or a technology, it is always suggested the most common countries that it is normally, which are rampantly applying for trade patents at a massive scale, are USA, China, Japan, India is there, no doubt around on it. So there are these two, three countries are working at a very massive pace in applying patents. So whenever you are going and you are sure that in a within 1 to 4 years you can stretch it, you can you can actually launch a business in all these countries. Make sure to go for application of a patent parallelly in all these countries, because it we have faced it quite a few times when you end up applying for it, and by that time somebody else would have already applied it internationally, and you were just left applying and securing your market in India, but you left the entire market internationally open for anybody else to come. So make sure you, when you're applying, apply it internationally considering your business scope.
Okay. What are the challenges in patenting autonomous vehicle technology that rely on light detection ranging, that is LIDAR, and sensor fusion?
So your question, if I'm right, like you're asking the challenges in patenting autonomous vehicle.
With LiDAR and sensor fusion.
Okay, so first the challenges. See, the challenges will be obvious. Ki there is high competition because there are a lot of existing patents in the public domain. Also, that you should be confident enough to be aware that your invention is truly novel and it is it is non-obvious, not an obvious invention. Also, the claims should clearly define specific technical advancement, like how this improved sensor fusion algorithm is involved in uh, detection of barrier detection, obstacle detection.
Understood. So I think that's all questions. So Karan and Pratap, I just wanted to know, just for the people who joined webinar. So there would be one specific, landmark patent case which both of you maybe, like you didn't expect that kind of judgment, or multiple cases like utility patents too much, like we had Samsung and Apple case. So both of you can tell each one cases, maybe not just related to patent, maybe it could be design or trademark, it could be anything, just as in the common error which such big companies also fail to see with the naked eye. Can you?
Yeah, I would like to cite one patent case that actually I was at starting discussing about that. It was very interesting case, the Reva technology versus Tata Motors. So what happens is a Reva system came up with a regenerative braking system. So what happens is obviously if something as known as electric vehicle has evolved, so our whole focus might be on improving the battery, right? So what regenerative braking system has done is that when the person is pumping the brake pedal, the battery is getting charged. How it is getting charged? Because there is not like what used to happen in traditional methods. There is something known as friction will be applied on the wheels and they will be stopping. No, actually the when the vehicle is moving in forward direction while applying brake, the same when the wheels are moving in forward direction when vehicle is going in forward direction, so they will be moving start moving in rear direction. Alternatively, it is actually applying the brake only, but it is not actually uh, stopping the vehicle. So what happens is that when your wheel is in continuous motion, it is actually producing electricity, and that electricity is used for charging those batteries. Now what they have done is that they have some specified set of rules which I was talking about, how we should write. Okay, I will tell you the importance of drafting here as well. They haven't they actually used various techniques and algorithms which have some specific set of rules. Suppose if my car is rolling in downhill, so in that case it will automatically be applying the regenerative braking system. So by the time it goes down, the speed will be constant, and based on that, it subsequently it is charging my battery as well. Tata also came with same invention, similar invention, but yes, what they have added is they have added generative AI technique into that. So now it has become some experience based. So it was actually noting down the actions of the driver, when he is applying brake and what conditions he is applying brake. So basically, he have used generative AI here. So basically, the case was actually settled in court itself. But yes, if Reva technology might have used or might have focused more on good drafting, so they might have covered this generative AI concept there as well. So I always say your draft should be as broad as possible. It should cover all the possibilities. If we are talking about some specific set of rules, we should also think of covering it in a broader way. Like it can be it can be done by the generative techniques. It may be done by some other techniques all over the like all around the globe. We have to refine those techniques and we have to include it in the draft itself. So tomorrow we will be having something to say in our defense, right? But some nothing happened in this case. I think Reva Technologies haven't offered any huge amount. It was actually settled, and it is actually not out how much they have to pay or how much they had received. So yes, the draft writing draft is, I think we should focus more on drafting claims, phrasing the claims. The person who's experienced to 5 to 10 years can only write good drafts. It's not something which everyone can do. So yes. So
Karan,
this was
it's on you now. We wanted to know your case, landmark, anything.
Yeah. See, I will see one aspect that I've seen across on one point. Regularly, cases are being filed or with respect to not appropriately following the licensing laws with respect to patent. So there have been a number of cases between Ericsson versus Lava, Ericsson versus Motorola, Ericsson versus again different companies who ended up creating a different kind of software-based products, which is commonly required by anybody else for developing the same product or a similar product. In such cases, there is always a prior permission that has to be taken from a person who has applied for from who has already applied for a patent, or a kind of a license has to be taken from them. And majority of their million dollars of cases that are being filed not only in India and internationally. So what as companies, what as individuals, you need to see few things. Firstly, whenever you are creating some patent, whenever you're creating that idea, make sure to have a regular check of the same if anybody is trying to copy, and if anybody is using a similar kind of a product, have they even taken a license from you or not? If not, you need to take appropriate action against them, because patent is a way for you not only to make money but also a way to expand your overall product or the patent internationally so that people know. And if everybody starts copying it, the entire purpose of your patent becomes nil. So make sure if anybody tries to copy it, you take have a proper check mechanism, have a proper check across the world. If anybody is using something similar, take actions, not in a way to stop, but see how you can make a business out of it.
right. And right. And as Karan sir have talked about this thing, how the person will be actually knowing that someone is using. For that, you have to conduct freedom to operate search, where you will be seeing whether the product launched in the market is actually infringing your patent claims or not. Basically, specifically the independent claim. If you found so, then you can have the further business process with him.
Okay, I think that's the wrap for the webinar. Thank you, Karan. Thank you, Pratap, for giving your time. It was wonderful, getting great industry insights. So, the people out there, if you want to reach, you can get in touch with our experts, and I've given a feedback form where you can fill it. Or if you want to take an expert consultation, I have dropped the link here, and you can, get in touch with our experts. You can schedule it, and that's it. Thank you, Karan. Thank you. Thank you all. Thank you, Pratap.
Thank you.